Hi, and welcome to today's webinar, Trademark Basics, What Every Small Business Should Know Now, Not Later. I'm Esmeralda Estrada from the Maricopa SBDC, and I'll be the facilitator for this webinar. If you have any questions, could you please just place them in the Q&A chat and Q&A box, that way we don't lose them in the chat. I'll be talking to you all in the chat as well as Lou. Thank you all for joining us. If you'd like to start by introducing yourselves in the chat, we would be happy to get to know you all. For now, we'll have Lou introduce himself and the Maricopa SBDC.
Perfect. Thank you very much. Let's see. All right, there you go. Good morning, everybody. This is Lou Farina from the SBDC. Some of you I know, some of you I don't, but to everybody, welcome to this webinar. I'll be your host today on this particular topic, and we've got a guest speaker that will provide the bulk of the material. I do have to apologize. I'm having some technical problems and I will be off camera, but I promise you, you're not missing anything. Okay, so let's get into it today. This is about trademarks, and there's some topics for today, and I see some typos here, but I apologize on that. How trademarks and copyright, patents, domain names, businesses name registrations all differ. The benefits of the trademark registration process, why it's important, some critical factors. The USPTO's role in the registration process, and how to get free and reduced legal help when applying for registration. So we're going to cover a lot of material. Jason's going to cover a lot of material today. But before we do, I'm going to tell you a little bit about the SBDC. The SBDC is part of America's SBDC network. We've got, there's a national network of SBDCs in Arizona. We've got a state network. There's 10 centers in Arizona. There's 17 counselors in Maricopa County. It's one of the 10 centers, but there are centers all over the state. We do basically three things as counselors and advisors. We do counseling, and it's no fee. And some of you have taken advantage of that. For others who have not, I encourage you to explore. We do training. Training is what we're doing today. We used to do in-person workshops. Last 18 months, it's been webinars. And I'll talk to you a little bit about some of our upcoming webinars at the end. And then there are some resources or some tools that we've got. And I'm going to talk to you a little bit more just about that. So, on the counseling side, we do a lot of, we cover a lot of areas, and we have our counselors or specialists in different areas. And at the top of the list right now, and really maybe we should be starting to move that down to towards the bottom, is disaster loan assistance. It's not something that the SBDCs has traditionally done, but over the last 18 months, we've taken a lead role in helping the business community access those programs. More traditionally, we do a lot of lender readiness preparation. So if you need an SBA loan, any kind of loan, we've got some specialists in capital and loan preparation that can help you. We've got financial folks to review your financials and resiliency, marketing, buying and selling, exiting strategies. We've got a specialist in manufacturing. I'm the specialist in technology commercialization. We've got export and international trade specialist. And then we've got a sister organization called PTAC, which does nothing but government contracting. We could talk more about that. So just a little bit on the tools, and I've got a fairly busy slide up here. I'm not going to go through each one in detail, but Growth Wheel is a tool and these are all no fee to our clients that will help you focus on areas that are critical to your business, help you prioritize and then focus. Live Plan is more of a business planning tool online. It's very powerful. For those of you who have to write business plans, if you're going for funding, either private equity or even to a bank, you've got to have a business plan. This is a way to get started and very easily collaborate. We've got Profit Sense, which is really does industry comparison to your business. So if you're an existing business, you've been running for a while, and you want to compare your financials against other businesses, competitors in your either geography or your business segment, we can do that for you. We could do a ratio analysis, help you understand your financials. We've got some market research services, sbdc.net, which does some custom. And then we've got IBIS World, which is a more of a packaged type of market research repository where you can pull reports. And they're actually very broad reports in subject, but they're fairly deep too, and they're very useful if you need to cite third-party market research. So we encourage you guys, as you become clients, we can use any of these tools. So we're going to do a quick poll here, and the poll is: have you filed for a trademark? And Esmeralda, can you run that poll?
I sure can.
Excellent.
So I have launched the poll, and I will let you know if once people have answered.
Perfect. And will you be able to flash the results for us?
Yes, I will do that in 5 seconds.
Okay, thank you.
All right, so we've had 23 answers, so I will end the poll now and launch the results.
Okay, terrific. So we've got a lot of folks who are here to learn about trademarks, and I think you're in the right place. Jason is very knowledgeable. I'll introduce him here in a second. And a couple folks who've got an application in for a federal trademark, and a couple folks, or 3 folks who've actually had federal trademarks. So terrific. Welcome everybody. Okay, so I'm going to introduce here to you Jason Lott, and Jason is an attorney for the USPTO. He's an advisor for trademark education and outreach. I won't read you his entire bio, but we are really lucky to have him here, and he's a wealth of knowledge, and I'm going to turn it over to Jason at this point. So Jason, all yours.
All right. Well, thank you very much, Lou. Appreciate it. Appreciate the invitation to be here today. I will share my screen so long as Zoom cooperates. All right, here we go. Well, hey there, everybody. My name is Jason Lott. I'm the attorney advisor for Trademarks Customer Outreach at the USPTO. And it's really a long way of saying that it is my job to teach you about trademarks, what they are, why they're important, and how a federal trademark registration can help you build your business. So it's great to see in that poll right there about how many of you are just learning about trademarks, because so this is an awesome time for you to be learning about trademarks as you're just, say, getting your business off the ground, because you want to lock down your intellectual property, lock down your trademark as early on as you can. And it's great to see that some of you already have some experience as well, having submitted an application, and some of you lucky folks already have a registration. That's awesome. So we're going to talk about a lot of different things today. We're going to talk through the basics of trademarks, sort of what they are, and the sort of different versions of trademarks that you can apply to register with the USPTO. We're going to talk through the benefits of federal registration. We're going to talk about how to select or choose or create a strong trademark. And we're going to talk about very quickly about filing and registration. And then I want to talk also very briefly about how to find help, because I would like to spend as much time as possible at the very end answering your questions. I'll answer any question that you can throw at me. I might not always be able to provide an answer because I can't give legal advice, but I'll answer any question that you throw at me, and I'll try and get you an answer. So let's talk through some of the basics of what a trademark actually is. Well, as you can see on your screen, this is the sort of technical definition of what a trademark is. If you want to talk about a legal definition, it's any word, symbol, design, or combination of these that does 2 things. It identifies the source of goods, and it distinguishes them from the goods of another party. But it's a really wordy way to think about it. I think the quick and easy way to think about it is that a trademark is legal protection for your brand. And if you think about a trademark being a brand, like a brand name or a slogan or a logo or some sort of design, that goes a long way towards helping you understand what a trademark actually is. So for example, we just had a Labor Day holiday a couple of days ago. So some of you might have spent some time in the backyard with a cookout, right? But before you went there, you had to go to the store and figure out which hot dogs you were going to buy. And how did you decide which hot dogs you wanted to buy? Well, you were probably using a brand, and probably more specifically using a trademark that you saw on those packages of hot dogs. So it could be that you're a Nathan's family, or maybe a Hebrew National family, or maybe a Ballpark family, or a straight up Oscar Mayer Wiener family. Or maybe if you're plant-based, maybe you like stuff like Tofurkey dogs or Light Life or Field Roast or even a Beyond Brat, right? So what you're doing when you're using those trademarks and those brands, you're using those to identify the source of the goods that you want. These are the hot dogs that I want. These are the hot dogs that my kids will eat. They won't eat any other variety, right? So you're using that trademark to identify the source of the goods you want, and you're distinguishing them from the goods of another party. So if you're a Hebrew National hot dog family, then you're going to get those, and you're not going to get Oscar Mayer or the store brand or whatever it happens to be. So what you're doing there is using that trademark to identify the source of goods and distinguish from the goods of another party. And it's incredibly important that you understand that trademarks are always, always, always tied to very specific goods, right? So if we think about, if you think about, Ballpark Franks, what comes to mind? Hot dogs. If you think about Coca-Cola, what comes to mind? Soft drinks. Ford, cars. Levi's, jeans. Budweiser, beer. Right? So every single time you see or hear that trademark, you automatically think of a very particular set of goods that is provided under that mark. And it's very important that you understand that, because without that connection to underlying goods, what you're talking about is not a trademark. So a trademark is always, always, always tied to very particular goods. And so when you're thinking about your business, the business that you're creating, or maybe that you're already running, think about what goods you are providing under your trademark, because when you apply to register your trademark, you're going to want to know what those are, because you're going to have to identify those in your application. Now, I've been focusing on goods, but really it involves services as well. If you want to get super technical, then trademark indicates the source of goods and a service mark indicates the source of services. But honestly, folks, don't worry about it. You can just refer to something as a trademark, even if it refers to services, and it's totally fine. People do that all the time. Trademark is an all-encompassing term. You can even refer to it as just a mark, and that's totally fine. And you'll probably hear me say that throughout the day today. So what you're seeing on your screen now are traditional types of trademarks, or traditional versions of trademarks that you might want to register. So I want to give you just sort of break it down quickly and start thinking about your trademark right now, right? What you use to indicate the source of your goods and services. And I want you to think about the fact that you can register different versions of that trademark that you use. It is up to you when you file to protect your trademark with our office. So if you think about Coca-Cola, all right, not exactly what it looks like, just think about Coca-Cola in general and the fact that Coca-Cola identifies the source of soft drinks. All right, so if you're Coca-Cola, you might want to register different versions of your trademark. You might want to register what's referred to as the word mark version, which is protection for the wording itself. Not what it looks like, but protection for the wording itself. So you could, if you wanted to, register the word mark, or as we refer to it, the standard character version of the trademark Coca-Cola. And the great thing about it is that it provides this incredibly broad scope of protection, because because you're getting protection for the wording itself, that means over the life of the trademark, you can use it in whatever font, style, size, or color you want to. You're not locked into your trademark appearing only in a very specific way. And that's really broad. It may sound limiting to say, oh, I'm just registering the wording itself, not what it looks like. But actually the opposite is true, and it unlocks this really broad scope of protection. Now, as you can see on your screen, there's also what I've referred to as stylized, composite, and design marks. So Coca-Cola in script font with the red coloring. And then down on the bottom, a combination of wording and design with the Always Coca-Cola sort of, button there with a bottle on it. And also a design mark is really, it's it's just kind of a design without any wording. So it's protection for just sort of what something kind of looks like. And you are more than welcome to apply to register those types of versions of your trademark. If, for example, there's something about the trademark, the way that it looks, that is incredibly important to you, and you're like, I have to protect this aspect of my trademark, sure, absolutely. You can file an application to protect that version of your trademark. We typically refer to those as special format trademarks. And the reason that I bring up standard character and special form is because that will come into play when you're actually filling out your application. And for those of you folks who have already filed or have received one, you'll know exactly what I'm talking about. But I want you to start thinking ahead and thinking about your trademark. And don't think about yourself being limited to only protecting one particular thing, because you could protect different versions of your trademark. And you're not limited to just one. You could file as many applications before the office as you want to. So if you want to protect just the wording itself, cool. If you want to protect that sort of special form, a stylized version, or if you want to protect just the logo alone, yeah, you can do that. You can file multiple applications. Just keep in mind that each application can only have one version of your trademark in it. All right, you can't shoehorn a bunch of things together and say, oh, I want to protect all these 4 different versions and I'll just throw it into one application to save money. No, that won't actually work. You have to do separate applications for each version that you would like to try and register. Now, keep in mind, I said that you would like to try and register. All right, it is up to you if you want to apply for federal trademark registration. And I'll talk more about that in just a second. But I also want you to be aware of these non-traditional types of trademarks that are out there. So it's not just brand names and slogans and logos. Pretty much anything can be a trademark so long as it indicates the source of goods and services. So as you can see there, sound can be a trademark. They don't use it too much anymore, and I'm not the best singer in the world, but bum, bum, bum. That's the NBC chimes. And so anytime you would hear those chimes, you would know, that's NBC radio or NBC TV programming. Think about the MGM lion that roars at the beginning of a movie. You're like, oh, I hear that roar. I know that must be an MGM film I'm about to watch. Color can be registered on its own. If any of you have seen that hot pink insulation that goes into homes, that pink color is actually a registered trademark of Owens Corning. Think about a Tiffany blue box. That Tiffany blue is also registered as a color. When you see it on a box, you know that's a Tiffany piece of jewelry that's going to be inside there. So all sorts of things can be registered as trademarks so long as they indicate the source of particular goods and services. All right, so those are the basics of what trademarks actually are. They indicate the source of goods and services. Now, I want to also talk about the difference between a trademark and the federal registration of the trademark. So as you can see on the screen, your trademark rights can be created in a couple of ways. One is under common law, and one is through federal registration. So common law trademark rights pretty much are created as soon as you begin to use something as a trademark. So as soon as you say start selling your goods that you've created, or you open up your restaurant, or you start your food truck and you're out selling barbecue, or whatever it is that you happen to be doing, as soon as you begin to use something as a trademark to indicate the source of your goods and services, you are creating trademark rights. Now, these rights are created under state law. So it's going to be, I'm not sure what it is in Arizona, but I'm sure it's it's probably by a statute, or maybe it's through court cases. But your rights are beginning to accrue as soon as you begin to use your trademark. Now, as you can see on the screen, your rights are limited to the geographic area in which you are operating. So if you're only operating in and around the Phoenix area, then that means your rights are kind of only limited to the Phoenix area, because that's the only place you're actually using your trademark. If you're selling things online, it gets a little bit, it's a little bit more expansive at that point because you're not just selling in Arizona, but you're selling in all kinds of places, probably across state lines. And we'll talk about why that's important in just a second. But for sort of, illustrative purposes, let's just say that you are only selling in the Phoenix area, and that means that your rights are only limited to that Phoenix area. And as you can see on the screen, there's the symbol of a TM or an SM. TM stands for trademark, SM stands for service mark. As soon as you begin to use something as a trademark, you are more than welcome to put a little TM at the end or put a little SM at the end. It's up to you. Because what you're doing is you're putting people on notice that you are using something as a trademark. There's no requirement that you use it. However, it's often recommended that you do because you want people to know, hey, this is my trademark. Don't start using Jason's barbecue as a trademark because I'm using it for my barbecue food truck that I have. Okay, so you're welcome to use the TM or the SM. You cannot use the little R in the circle symbol because that's the symbol for federal trademark registration, which is different than your common law trademark rights that you create under state law. So let's say that you've started your business in Arizona, you're doing a great business, you're beginning to grow, and you're selling across state lines or you're providing services across state lines. Well, yes, your common law trademark rights are beginning to grow, but you also want to make sure that, hey, I know that I'm going to be operating, across the United States before long. Or maybe you're in a business, like I mentioned, that is an online seller, and you're selling your goods across state lines to people all over the United States. Well, in that case, what you would probably want to do is try and register the trademark that you have been using with the federal government. So essentially, you're no longer relying just on the sort of geographically small state rights that you have. And instead, by registering your trademark and saying, hey, USPTO, here's the trademark I'm using. I would like to register it with you. And we say, oh, yeah, this one works. Okay, cool. Here you go. When you do that, when you register with us, you get these nationwide rights. It creates a legal presumption that you own that trademark and that you have the right to use it throughout the United States and its territories. You're putting people on notice about your nationwide rights. You can bring legal action concerning your trademark in federal court, which is great. So let's say that you have your nationwide rights, you're selling all over the place, and all of a sudden somebody pops up in, North Dakota, and all of a sudden starts selling, trying to do something that's really similar to yours. Well, if you didn't have that federal registration, you would need to go to North Dakota and sue that guy to stop him from infringing on your trademark rights. But because you have a federal trademark registration, instead you can do a simpler thing, which is just go to the federal courthouse that is nearest you and file a federal lawsuit concerning your trademark in Arizona. And you make the guy in North Dakota have to come to you in order to defend and say, whoa, I'm not actually infringing, right? So it's a great benefit to you. So you don't have to go all over the place trying to track down infringing users. And instead you can make them come to you. And as you can see at the bottom of the screen, another great benefit is you can record your registration with U.S. Customs and Border Protection, which is a fantastic benefit if you are operating in a field or industry where there is a lot of counterfeit goods. So if you record your registration with CBP, they will try and stop counterfeit goods that bear your trademark from entering the country. Which is great because that means that they're able to do it because they're in the best position to try and do it. So you don't have to be hunting around the docks and, and things like that, airports and whatever where stuff is coming into the country. But CBP can take care of that for you. Also a really great benefit. Another benefit is that you can use your registration as a basis for filing in another country. So let's say you're doing so great here in the United States and you want to get protection in Mexico and in Canada and places throughout Central and South America. Oh no, also you're going to be going into Europe and into Asia and into Africa. Well, guess what? You're going to want to have protection for your trademark in all of these other countries in which you might be operating. So you can use your registration to extend protection into these other countries. And that's a really great benefit because keep in mind, there is no such thing as a sort of international trademark registration. All right. So just because you register with the USPTO, that does not mean you have protection around the world. It's only protection in the United States. If you want protection in another country, you have to apply there. And by being able to extend your protection through what's called the Madrid Protocol, then you're able to more easily begin those applications in those other countries. And of course, as you can see there, the other great benefit is that you get to use the little R and the circle symbol, which is the gold standard when it comes to trademarks. You want to be able to put that little R in the circle next to your mark to let people know, hey, this is my trademark. It is registered with the federal government. Back off. All right, so now that we know what a trademark is and we know why we might want to register that trademark with the federal government, let's talk very briefly about how to select or choose or create a strong trademark. So as you can see on the screen, our mission as the USPTO is to register trademarks. We want to register your trademark. In an ideal world, we would register every trademark that came in through the door, but that's not actually how things work. And there are lots of reasons why a trademark might be refused registration. And we'll talk about a couple of those in just a few minutes. So keep in mind, as you can see, that not every trademark is registrable. It could be refused registration. And in addition to that, even if your trademark does register, it might turn out that your trademark is not enforceable, which is crazy when you think about it. When I first learned, I was like, that can't be right. But it actually is right because of common law trademark rights, because those rights are based upon use. And so trademark rights in the United States begin as soon as you start using that trademark. So it's quite possible that there could be out there a company that has incredibly strong trademark rights, but they have never registered their trademark with the federal government. So let's say, for example, that Levi's just never got around to registering their trademark. So it could be they could be relying on their common law rights. And you being a smart person, you look in our database and say, look, there's no registered trademark for Levi's for blue jeans. I'm going to register Levi's for blue jeans. Well, if there is nothing else in the database, it's quite possible that we would say, okay, you can register Levi's as a trademark for blue jeans. Well, guess what? You get that registration and all of a sudden Levi's is like, no, I don't think so. We have these prior common law rights, which are incredibly strong. We've been using a brand since, the late 1800s or whatever it is. And so they could end up challenging and eventually canceling your trademark registration, even though you went through the whole process in order to register the trademark. So obviously we want to avoid that situation, right? You don't want to go through the whole process and the time and the effort in order to register a trademark and then end up discovering, oh, I can't enforce it. So as someone who is, say, just starting out or just beginning to build your business, you want to make sure that you can select a trademark that is both federally registrable and legally protectable. And the two things I'm going to talk about right now are going to go a long way to helping make sure that yours is registrable and protectable. And the two things we're going to talk about are likelihood of confusion and strength of the trademark. So with regard to likelihood of confusion, the way that you might have heard about it before is that people talk about infringement, a trademark infringement. Oh, that he's infringing on my trademark rights. And really what we're talking about is the fact that consumers are confused when they see both of your trademarks in action. So the test that it comes down to is this likelihood of confusion test, and it's a confusion as to source. So when you apply to register your trademark with the USPTO, the trademark examining attorney assigned to your case is going to do a search of our database. And she is going to be looking to see, is there some other trademark in our database that is likely to cause confusion with yours? And the test that the examining attorney uses to determine this is what you see on your screen. I mean, it's a bit more complex than that, but for the most part, it boils down to those two main points. Are the trademarks themselves confusingly similar? And are the goods and services provided under those marks related? Now, notice I didn't say identical for either one of those cases. It just has to be, are the trademarks confusingly similar? Do they sound alike? Do they look alike? Do they have a similar meaning or similar commercial impression? And with regard to the goods and services, what that really means is, does one company typically make or provide both of those types of goods? Or does one company typically provide both of those types of services? And if so, if the answer to the first prong of the test and the second prong, if that answer is both yes, then there's a likelihood of confusion in that case, and your trademark application would be refused registration. So just let me give you a really quick example. So let's say that you are Delta Airlines, and you want to try and register the trademark Delta for air transportation services. So what would happen is the USPTO examining attorney would get your application and she would take a look at it, look in the database. Are there any other Delta marks that are out there that are likely to cause confusion with yours in your application? And she might look through and say, here's one for Delta, and it's for plumbing fixtures. So let me do a real quick analysis here. Are the trademarks confusingly similar? Yeah, well, actually, they're kind of identical, but they certainly sound alike and look alike. So the first prong of our test is completed. Yes, the trademarks are confusingly similar. So she would move on to the second part. Are the goods and services related? Does the company that provides airline services also typically provide plumbing fixtures? No, right? So in that case, there wouldn't be a likelihood of confusion. And so Delta for airline services and Delta for plumbing fixtures could absolutely coexist because consumers are not likely to be confused when they encounter both of those in the marketplace. So what if, however, you had your Delta for airline services trademark application and the examining attorney discovered in the database that Delta for travel agency services had already been registered? Would that be a problem? Good question. It could be. The trademarks are obviously confusingly similar, so the answer would really depend on whether airline services and travel agency services or travel booking services are related. Does the company that provides airline services also provide travel booking services? They might. Or travel agency services, those sorts of things, they might. Would a consumer be confused into thinking that, oh, I see Delta for airline services and Delta for this travel booking. I bet that's the same company where I've got my, I'm part of their frequent flyer program. Yeah, maybe I'll go ahead and use that, right? So at that point, there could be a likelihood of confusion. And so your trademark could be refused registration. So you want to avoid that situation where you apply to register a trademark and then discover, boy, there's already something in our database of applied for and registered federal trademarks that is likely to cause confusion with your application. So what we recommend you do is what is referred to as a clearance search. And it's called that because you're essentially clearing the area around your trademark to make sure that there's nobody out there who's using a same or similar trademark for related goods and services. Now, a true, full, comprehensive clearance search is pretty complex. So we always recommend you do at least two things. First of all, look in our database, and you use the Trademark Electronic Search System to do that. Tests is available 24 hours a day, 7 days a week for free. You don't have to pay anything. You can just click on the link there and go into our system. I'll tell you right now, between you and me, it's a little bit antiquated. It's been around for quite some time. They're working on an upgraded version of tests. It's not ready yet, but hopefully it will be, and it hopefully will be easier to search because the version that is up there now, it takes some time to learn how to actually use. But we would recommend at a very, very basic level, do a search in tests to see, is anybody in that database, are they using a same or similar trademark for related goods and services? And of course, the easier thing to do, and which we also recommend, is to search online, right? You want to see, is Levi's for blue jeans out there and they've just never gotten around to registering it with us? If so, you're going to want to know about it, right? So do that search using Google or Bing or Yahoo or whatever search engine it is that you prefer. Actually, use them all, right? Because they all have different algorithms. So you might want to check around and see if you can uncover something that's out there. And so look to see if there's any common law usage that is out there that you were just unaware of. I think, here we go. Okay, so in order to do a full-on clearance search, we would recommend working with a private trademark attorney, someone who's experienced in trademark matters, because that attorney can do that a full clearance search for you, right? Looking in our database, looking in state trademark databases, business name registries, foreign trademark databases, also doing that common law search online. It can get pretty complex doing a clearance search. So this might be a case where it really makes sense to work with an attorney because the attorney is going to be able to advise you and say, look, I did this search of all these things. Most of them are not a problem. This one concerns me a little. This one does too. Let's do a little bit more research into this and figure it out. So that's what we recommend anyway for doing a full comprehensive clearance search before you actually file your application with us. Now, so that's one. That's the strength of the trademark issue. I'm sorry, the likelihood of confusion issue. The second thing that you're going to want to think about is the strength of your trademark, because the strength of your trademark will play into how easy or hard it is to protect your trademark and eventually your trademark registration. So this is often referred to as the trademark descriptiveness spectrum, but I like to think about it as a temperature gauge that goes from weak to strong or cold to hot. And where you want to focus your attention are on those strong trademarks, those hot trademarks, which are fanciful trademarks, arbitrary trademarks, and suggestive trademarks. So let's take a look at some examples to help us understand what we're talking about here. For fanciful trademarks, we're talking about made up words. Okay, they're words that have no meaning in English, no meaning in any foreign language. And it's just whatever. Xerox for copiers, Kodak for cameras, Exxon for gas, right? So those words don't have any meaning in English or in another language. Now, for you and me, and as consumers, yeah, they have meaning because we have now come to associate. Anytime we hear Xerox, we think photocopiers, Kodak, cameras, Exxon, filling station. Okay, so we now have that relationship in our minds between the trademark and the goods or services, but there isn't one with regard to the strength or the descriptiveness of the trademark. So fanciful trademarks are great. They are inherently distinctive. They're going to be easier for you to protect in the long run. Same thing with arbitrary trademarks. Arbitrary trademarks, those marks have meaning in English or in another language, but no descriptive meaning when it comes to the underlying goods or services. So Apple clearly has meaning as a type of fruit, but it has no relationship to computers. So Apple being a common everyday word, registered as a trademark for computers, no problem. The Gap for clothing, no problem. BlackBerry for mobile devices, no problem. So even though those words are common words or phrases that we hear all the time, they are registrable because they have no descriptive relationship with the underlying goods or services. So fanciful trademarks, arbitrary trademarks, awesome. Those are really strong. They're really going to help you in the long run to protect your trademark and your trademark rights. Now, slightly below fanciful and arbitrary trademarks are suggestive trademarks. These are ones that suggest something about the underlying goods or services, but they don't exactly describe them. So the example here, copper tone for suntan lotion. So you kind of get what it means. Okay, if I use the suntan lotion and I go outside, my skin will take on a coppery tone. Yeah, okay, it kind of suggests what might happen if you use the product, or maybe how you might feel about the product if you use it. So suggestive marks are inherently distinctive. You can register those at our office, no problem. But there's just like that slight disconnect or that one step between the trademark and it being descriptive of the goods or the services. Now, below suggestive trademarks, and technically not registrable on the principal register, which is the main trademark register, those are descriptive marks because they describe something about the underlying goods and services. So here, creamy whip is descriptive of whip topping, right? Because you can tell from the trademark, it's whip topping that is creamy. It is not functioning as a trademark because what does a trademark do? It indicates the source of underlying goods and services. So when you see creamy whip, does that automatically call it? Well, actually it does. It calls to mind, oh, it's a whipped topping that is creamy, right? So it's not functioning as a trademark to indicate source. It's just telling you something about the goods. So there are ways to register descriptive trademarks, but you have to jump through several hoops in order to do it, or you have to be in a certain status in order to do it. So in terms of your strength of your trademark, yeah, maybe it's possible to register it, but also think about in the long run, how strong is your trademark going to be? How easy is it going to be for you to protect that against other, say, whipped topping trademarks that are like creamed whip or whippy cream or, cream and whip or, something like that, right? They all kind of sound similar. They're all kind of descriptive. So ask yourself, is a consumer going to easily be able to differentiate my product from my competitors? No, probably not, because of that descriptive trademark. So that's why we always recommend suggestive, fanciful, arbitrary trademarks are a great way to go to make sure you have a strong trademark that you can protect over the years. Now at the bottom, you can see they're generic. Generic marks aren't even marks at all. They are not trademarks because they just tell you what the thing is. Milk for a dairy-based beverage. You would never be able to register milk as a trademark for a dairy-based beverage because milk tells you what the thing is. Therefore, it is not source indicating, and it is just telling you something about the product. So bicycle for bicycles, never going to register as a trademark. Bicycle for playing cards, yeah, that could, because it is arbitrary. The trademark bicycle is arbitrary when used with playing cards. So there you can sort of see the difference between them all. All right, so those are the two big things, likelihood of confusion and strength of the trademark. I want you to think about those and think about your trademark. Think about what you are using to indicate the source of your goods and services. All right, now I'm going to very quickly talk about filing and registration. I'm not going to go too in depth because it's an incredibly weedy topic and we don't have enough time for me to go into it all the way. So I'll just kind of give you a couple of basics. In order to apply to register your trademark with us, you have to create a USPTO.gov account. This is a newer thing. It's started maybe a year or two ago. And it's just like any other website where you have to create an account. Yeah, same thing here with the USPTO. And the cool thing is, though, it provides some layers of security, and there's more security, which is going to be coming in the future. And it also creates an intellectual property portfolio for you at the USPTO. So you can access all of your trademark applications and registrations and patent applications and patent grants all through the USPTO.gov account. And once you have that account, you can file your application through the Trademark Electronic Application System. And there are two versions of the initial application form. There's TEAS Plus and TEAS Standard. We always recommend that folks file using TEAS Plus because it's the cheaper option. The standard fee is $350 per international class. But if you use TEAS Plus, we give you a discount of $100 off per international class. And that's because the TEAS Plus application is a more efficient form. There are things that you're going to have to, at some point, provide to us. And so what TEAS Plus does is it says, in exchange for you front-loading your application with all this stuff that we know we have to have, we are going to give you $100 off per international class. So it's more easily the TEAS Plus application is more easily going to flow through the examination process. I mean, it gets the same level examination, but because you've put everything in there, there's often less back and forth between you and the examining attorney. There are less things to fix, less things the examining attorney has to ask for. And so you're 20% more likely to move on towards publication and to registration when compared to a TEAS standard application. Now, some of you might be wondering, Jason, you said there's no such thing as an international trademark. What is this international class nonsense? Well, I'll tell you, international class actually refers to the fact that we have international agreements with other countries around the world, that goods and services are all divided up into 45 different international classes. So chemicals would go in one class, metal goods would go in one class, power tools in one, manually operated tools in another, vehicles in another, clothing in another, types of foods and beverages and different ones, and services. So retail store services go in one, restaurants go in another, movie production services go in another, right? So everything is divided up into 45 different international classes. And when you file your application, you will have to identify the goods and services that you use under your trademark, right? Because trademarks what? Indicate source of goods and services. And so because goods and services are divided up into international classes, your cost of your application is going to be based upon the sort of result of how many international classes end up in your application. So if you want to register Jason's Barbecue for food truck services and also for t-shirts, well, food trucks are in class 43, t-shirts are in class 25. That's 2 different classes. So your filing fee would be $250 times 2 for $500. Now remember, it is your choice what to include in your application. So if you're like, Jason, I got $250 I can put toward my federal registration. I can't do both. Hey, no problem, right? You don't have to. You could choose which one is more important to you. Which one gets more play, on Instagram and through your advertising and however you're doing your food truck. Well, maybe it's going to be your food truck services. So maybe it's more important that you register Jason's Barbecue for food truck services than it is for those couple of, swag t-shirts that you also sell. So you could, if you wanted to, if you only had the $250, apply to register Jason's Barbecue for food truck services. And then later on down the line, if you want to, also submit an application to register it for the t-shirts. All right, so I'm including a little graphic here and a link to the trademark pre-filing checklist. So before you file, there is this checklist. We would recommend you download it. I'm going to provide a copy of these slides to Esmeralda so she can provide them to you. So you can download a copy of the checklist. Some things to think about before you actually file, because there's a lot to go through. And just a couple of quick reminders, it is up to you to enforce your trademark rights. The USPTO is not an enforcement agency, so there is no trademark police. So it is up to you to protect your trademark rights, which is why we also recommend you work with an attorney. And you also might, in order to keep your registration alive, you are going to have to file post-registration documents with the USPTO. There are 2 main ones that you'd have to file. The Section 8 is due between the 5th and 6th years. And then the combined Section 8 and 9 is due between the 9th and 10th, and then every 10 years thereafter. Again, these are things you could file on your own. It often helps to work with an attorney because the attorney might have a docketing system that helps. But hey, look, we all have calendars on our phones. You could put a little reminder in your calendar or in your phone itself. Hey, remind me in 5 years I have to file that Section 8. And so that's another way to do it as well. And these forms are pretty simple to fill out. So it's something you could absolutely do on your own. And also just a quick notice as we wrap up and we can get to questions, that your information in your application and the registration are made public. That's a requirement that the Trademark Office makes information in applications and registrations available to the public. So because of that, there are companies that will scrape our database and then send you misleading solicitations and offers and notices and things like that. Now, some of them are legit, but some of them are not at all legit, and they are trying to trick you into paying money for things that you do not need to pay. All right. So you might see some sort of solicitation from a company that might be asking for 4,000 euros in order to get on some private European registry or something like that. No, none of that stuff is required. Anything that the USPTO is requiring you to respond to or needs you to pay a fee for, you can find all of that stuff on our website through the Trademark Status and Document Retrieval System. So you can look up that information, and if you don't see a copy of what you have in your hand that came through the mail, well, you can probably ignore it because it is not coming from us. And I can talk more about that if you want to learn more. And also you can see there the link to the trademark solicitations page. Lots of examples of some of these shady offers that people have sent in over the years. All right, I'm very quickly going to find help. And then we'll talk through some questions. So as you can see, our website has a lot of great resources. Plus, we have a downloadable booklet. We have lots of videos. You will unfortunately see me in most of them. So hopefully you'll find those helpful. we have our Trademark Basics Bootcamp. So this is an 8-week cycle. You don't have to attend every single week. It's absolutely free. I will be talking to you for 90 minutes every Tuesday. It's, I guess it would be 11 a.m. your time, at least the current time zone anyway. And I take you through trademark basics like we talked about today. We get really weedy in terms of how to do a search of our database. And also there's another week where I take you through the actual online application form and show you on this page, you do this, on this page, you do this, on this page, you do this. And lots of other things. If you want to learn more about post-registration requirements, we have a whole section about that. We actually have that one coming up next week. And then we close out every single boot camp with a Q&A panel where you get a chance to ask questions of a couple of trademark experts from our office. So if you're interested in signing up for Trademark Basics Bootcamp, we would love to have you there. The next cycle begins on October 5th. And runs for 8 weeks. So we'd love to have you sign up for that. As you can see, the link to that is at the bottom of the slide here. We also have the Trademark Assistance Center. These are our customer service folks. They love to work with you, love to help you out. They cannot provide legal advice, but they can provide general information and show you where to find things on the website, things of that sort. All right. Yeah, just the final reminder, of which I've already talked about. We cannot provide legal advice or help you enforce your legal rights. And we also can't recommend specific private attorneys. We recommend you might want to think about working with one. You do not have to if you are domiciled in the United States, but we recommend it. It's if you can afford it, then it's a good thing. There also are some free and reduced price legal services, which I can talk about like during the Q&A section. All right, so let's jump back to you, Lou, and I will answer as many questions as I possibly can in the time that we have remaining.
Terrific. So thank you so much, Jason. That was very, very informative and I think extremely valuable for our clients. So I'm going to share my screen. I think there's like 7 in the Q&A, Esmeralda, 7 questions. Maybe that's a place to start.
Yes, we'll start with the questions. If you'd like, I could read them out loud for you and
Sure.
You just begin answering. All right. So can you talk about conflicts with trademarks and domain names using similar .coms and the potential of encountering future problems and how to avoid problems with this?
Whew, that's a pretty deep question. I don't know. I might not be able to hit all of that, but let me hit a couple of basic things. So oftentimes there's confusion between trademarks and domain names, and people think I registered my domain name. That means I have a registered trademark, right? No, it does not. It only means that you have now registered. You now have a place to park your website, right? So the thing is that a domain name can function as a trademark, but it doesn't have to. So just say you're Amazon and you have registered Amazon.com as your domain name. Could you also use that as a trademark? Sure. And Amazon did that for a very long time. So they don't really do it too much anymore. But if you were in a situation where you've registered your domain name and you also use it as a trademark, cool. You could also register that domain name as a trademark with our office, so long as you're using it as a trademark. Now, it gets a little tricky when you start thinking about conflicts between trademarks and domain names. And especially you think about early on in the internet boom, there's a lot of cyber squatting that happened, and people are like, oh, I'm going to get Coca-Cola.com and make them pay. They got to pay me millions of dollars in order to get it back. Yeah, well, there are things that are in place now to try and prevent that sort of thing. But there are also situations where somebody might try and squat on a domain name, thinking that it would be something that you would want because it's so close to your trademark. So I am not allowed to give you legal advice, so I can't necessarily advise you on sort of the best way to handle situations like that. But you're absolutely right to highlight it as something to think about and be concerned about. So if you have your business and you have your trademark that you're using, you might want to think about making sure that you're registering, obviously the .com, but also think about all those other ones that are kind of similar to it. I know that there are companies that are out there that do it. They try and snap up the .net and the .info and things of that sort. So I know that's not the best answer to your question, and I'm sorry I can't give a more precise answer to it. If we have time, I'll try and do a little cleanup, okay, on that. What else do we have, Esmeralda? You're on mute, my friend.
You're muted.
Sorry. Like I said earlier, just something you forget. All right, so can you talk about T used on products instead of the R to show that it is registered trademark? Does the T protect the product differently than the traditional R for registered trademark?
So TM is the sort of basic indicator that you would use. There's no difference in amount of protection because the protection that you get is based upon whether or not your trademark is registered. So as soon as you start to use something as a trademark, you can absolutely, as a brand name for your product, yeah, you can use the TM on there. Cool, no problem. You're just letting people know that you're claiming it as a trademark. The difference would be in the amount of rights that you have would be the R in the circle. So because that means federal registration. So if you're thinking about, if I'm looking at a product and I see a TM and this one over here has an R on it, in terms of value, that R in the circle trademark probably has more value to the business because it is a federal trademark registration. And that means that, for example, let's say you're going to try and get financing, you could use potentially your trademark registration, your intellectual property rights as collateral. It might be like, yeah, you've got really strong trademark rights. We have valued your trademark to be X number of dollars. You can, borrow against that. Or if you're franchising, your franchisees are going to want to make sure that you have a registered trademark, because they don't want to get in trouble when they start using something in another city and then they get sued by somebody, right? So in terms of value, the R in the circle is what you want to go with because you eventually want to get to that R in the circle through a federal trademark registration. But the fact that one over the other, there's no real difference in terms of using one or the other. The important thing is the rights that are created through federal registration. What's next?
All right. So the next question is advice before filing for a mark that has common words in like T or lace and how to best ensure that it will be accepted before filing.
So I'm sorry, can you read that one again? It's about common words?
Yeah. So advice before filing for a mark that has common words in it like T or lace and how to best ensure that it will be accepted before filing.
Okay, so T and lace, like Lay's potato chips, is that what you mean?
No, like lace, like shoelaces, and then tea
lace.
that you drink. Yeah.
Oh, okay. Yeah, sure. So yeah, it's possible to register trademarks that have that common wording in them. But it's really going to depend on what your underlying goods or services are. So if it's, Jason's sweet tea, and I'm doing bottles of sweet tea, yeah, you could potentially register Jason's sweet tea. The thing that you would want to keep in mind, however, is that remember how I talked about descriptive wording is not registrable at our office? So what will happen is the examining attorney will say, in order to register your trademark, you will need to disclaim the descriptive wording. So if I try to register Jason's sweet tea, I would have to disclaim sweet tea because that sort of common wording, in this case, it's generic wording, really, for sweet bottles of sweet tea would have to be disclaimed. Same thing would be true with lace. If it's Jason's laces for shoelaces, I would probably need to disclaim laces because it's descriptive, if not generic, of my shoelaces that I'm selling. Now, the fact that that is in the trademark, no problem. It's totally cool to have it in there. A disclaimer just means you're not claiming exclusive right to use it. The wording stays in the trademark. The only thing would be on your registration certificate, there would be a note that states that you're not claiming exclusive right to use the word sweet tea apart from the mark as shown, or the word laces apart from the mark as shown. So in terms of sort of advice or things to think about, it's fine to have that sort of wording in your trademark. Just keep in mind you'll have to disclaim it. And it also means there are probably gonna be a lot of other people who might have that in there, right? Because everybody who does tea, bottled tea or cans of tea, well, they're probably gonna have tea, Arizona iced tea, gonna have that in their trademark, right? Same thing with laces and things like that. So it doesn't, for descriptive and generic wording, it doesn't necessarily affect your ability to register in comparison to other people doing the same thing. It would just be if you were trying to register the trademark Apple for something that's like kind of tech adjacent, well, you might run into trouble. So that's just something to think about anyway.
So we had a similar comment added to the Q&A, and I think it relates to this. So It's lace clothing combination of words to clarify.
Oh, lace clothing.
Yeah.
Uh,
And then another question added was, what if the two words were combined? So tea and lace, or tea and lace.
So it depends on whether the wording that's being combined still retains its descriptive meaning. So let's say it was, T spelled, or just the letter T and lace, and it was for a lacy t-shirt, right? Or a t-shirt with lace on it. Well, in that case, the wording could potentially be refused because it's descriptive of a lace t-shirt. It's a T with lace, or a lace tee, right? It's this sort of transposed words might not necessarily solve it. But if it's wording like that, but only one of the words is descriptive. So if it's TEA, and lace, and it's for I don't know, a lace, like lace that you would buy at a Michael's or something like that. Well, that could be okay, because T might be considered arbitrary when used with lace. So the combination of arbitrary wording and descriptive wording means that something could be registrable. Think about Jason's barbecue or Jason's sweet tea, right? In both of those, you're combining sort of an arbitrary word, or I'm sorry, an arbitrary word with a descriptive word. So hopefully that answers your question. I might be missing exactly what you're asking, but hopefully that's close to giving some sort of answer for you.
Yeah, it's related to a clothing company.
Mm-hmm. Sure. Well, I have to be very careful then in terms of how I respond, because I'm not allowed to give you legal advice. Okay, so I can't tell you, yes, you're fine, you can register that. I am not allowed to do that because we cannot provide pre-application, sort of analysis. So I can give kind of hypotheticals, but I can't actually tell you what to do in your particular case.
All right. Thank you. So the next question would be regarding confusion. We applied for and received our trademark for Heroes Light. We have used it for our LED lighting for over 10 years. At some point, our trademark lapsed. At some point, a trademark was granted to a German company for a similar use. They use Hero for auto LED lighting. How does this happen? What recourse is available?
Great question. So in that case, my guess is what happened is that at some point after registration, if it sort of, as you say, lapsed after 10 years, probably what happened is you did not submit what was called the combined section 8 and 9, the combined declaration of use and request for renewal, which is due every 10 years. So in that case, what happened was your registration, quote unquote, died. Now, that doesn't mean that you have lost your trademark rights, because remember, you would still have common law rights. The only thing that has happened here is that your federal registration has lapsed. So you would still have those common law rights that you could rely on, even if you don't have that federal registration. So that's my guess as to what probably happened. So it is something to keep in mind. You still have rights in your trademark. It's just you don't have the registration anymore. If you wanted to, you could reapply to register your trademark again, to get that federal trademark registration again. As you've identified, you might run into trouble because of this other company that's out there. So the question would then be, how do you go forward from there? And so this is a place where I cannot help you in terms of how to go forward. I can't advise you on what to do, but some things you might want to think about. I know that sometimes folks are very specific about the way that they draft their identification of goods to make it clear that they're not doing anything that is like the people who have already registered. Because remember, for a likelihood of confusion and refusal, we're looking at trademarks and we're looking at goods and services. So if traditionally a company that provides this type of light does not provide this type of light, there's no sort of overlap in customers, then it could be, again, I don't know, but it could be that the way that the identification of goods is drafted is unrelated to the one that is currently registered. So it might be that you could register depending on that. Another option would be, is that sometimes people will have agreements with other companies. Yes, it's okay, you're going to be using it for this, we're going to be using it for this. It's something that we are not allowed to recommend as the USPTO. We cannot recommend consent agreements. But I can tell you, as an examining attorney for many years, I ended up accepting those because two parties said, yeah, we understand that you, Jason, have said there's a likelihood of confusion here, but we know that in the real world, there isn't one. And if one does happen, then we will work together to work it out. And then you could submit that, and the examining attorney assigned to your case will say, okay, because you know best and you have agreed to this sort of thing. So there are some potential options that are out there. In your situation, I would probably recommend that you work with an experienced trademark attorney to try and figure out the best way to go forward. Because you don't want to be in a situation where you get in a fight with this, especially if it's a bigger company and things like that. So I would say you might want to look around and see if you can work with an experienced trademark attorney to help you. And I know those can be expensive. So the law school clinic is what we often recommend. The clinics that we have, we've partnered with law schools around the country, and they've created clinics that if you meet certain income eligibility requirements, you can apply to become a part of the clinic, and they will help you with your application. That probably doesn't apply to you here if you've been, you might be making enough money that you wouldn't qualify for it. But there are other things through the American Bar Association. They have lots of what are known as pro bono resources. You might be able to find someone there. And also through the International Trademark Association Pro Bono Clearinghouse. It's called INTA, I-N-T-A. It's their pro bono clearinghouse, and they work with individuals and companies. And again, there's going to be an income eligibility requirement, I believe, there. But I remember hearing a story. They worked with a winery in South Africa in order to help them get a registration. And they operate here in the United States. So that might be a place you could go as well and say, hey, I've got this situation. And especially if the folks that are part of INTA, these are really high functioning trademark attorneys from around the world. So that might be another place to check out and see if you can get some free or at least incredibly reduced price legal services through the pro bono clearinghouse. Sorry, that was a really long-winded answer. Sorry about that.
That's fine. There was just a comment, rather more of a comment than a question. It's that they don't seem to understand the difference. Headlights versus street lights doesn't seem to be logical. And that's anchoring onto the previous question. Right.
So when you say they don't see the difference, I guess the question that I would then ask would be, who do you mean by they? Is it a situation where the USPTO, you're saying you've applied for it and the USPTO doesn't understand the difference, or the other company doesn't understand the difference and they sent you a cease and desist letter? So that I would just sort of like want to know more. And again, I have to be very careful since I cannot provide legal advice. So
USPTO attorney.
Okay. Well, then it might also depend on the way that is written in the registration. And again, I have to be very, very careful because I cannot comment on cases that are pending and things like that. So it depends. Oftentimes, this is just me speaking generally, that oftentimes if a registration is the ID in a registration is written in very broad terms, then you run into a situation where it sort of creates this coverage, even though it's not exactly what they're doing. So if I had, I don't know, let's say I registered Jason's and I put in, motorized vehicles, four-wheeled vehicles or something like that, right? Well, that's really broad. If for some reason I was able to get that registered, well, and nobody else would be able to register Jason's for other sorts of things. Even if in real life, the only thing I was doing was go-karts, right? And you were trying to register a supercar that you have created, like they're unrelated. The same company is not doing both, right? But if the registration is written in a broad way, the USPTO has to interpret that identification of goods at its broadest. So that could be a situation there. And the only other thing that I will say is that another option is to file a cancellation proceeding before the Trademark Trial and Appeal Board. So if there is some reason to think that the registration should be canceled because it should not have been granted, or perhaps there's a narrowing, like, hey, they're not actually doing all of these things, they're only doing this very specific thing over here, then that might be something to also consider. Again, not legal advice. I cannot tell you what to do. I'm just trying to give you things to think about. And I'm sorry that you're having this situation, and please don't think I'm in any way trying to diminish or dismiss it. I can understand how frustrating that must be for you. So I would say if you can talk to an experienced trademark attorney, they might be able to help advise you on finding a way to work through it and be able to re-register your trademark.
All right, thank you.
Sure.
So there's another question. We have 10 questions. Just so you
Okay.
know.
Look, I'll stick around as long as you want me. Okay. So.
All right. So how do you work with the USPTO in the best way? They seem to have a language all of their own. Responses are incomprehensible and requests are nuts.
Requests are nuts.
Yeah.
Okay. Well, I'll say, so I can say three things. The best way to work with the USPTO is to make sure that you are, to the best of your ability, reading every single thing that it is the examining attorney is sending you. I agree that office actions that you get can be very overwhelming, right? And a lot of that, those are legal requirements. So we have to put in the office action the legal basis for the refusal or the legal reasoning why something is done. And that includes citations to cases, which sometimes you go, right? So yeah, because believe me, I used to write those letters. And so some of that is because those are things that have to be in the letter to make sure that everyone is apprised of the legal situation. I can tell you that the office is trying to move as much and as quickly as possible towards plain language to make sure that the communications that we have with folks are in plain language, to make sure that you can understand exactly what is being asked of you. And so you might find in office actions, maybe not you personally who wrote in the question, but oftentimes an examining attorney will include a summary of issues and say at the very top of the letter, these are the three things that we have to talk about. If the attorney has suggestions on this is the ID, this ID would be acceptable, or this is the disclaimer that you would need to include. Look for those clues throughout the office action. And you might even find one where the examining attorney says, in order to resolve these, feel free to give me a call or, shoot me an email. Because if there are easy things that can be figured out, such as fixing an entity or fixing an ID, well, the examining attorney can take care of that stuff over the phone through what's known as an examiner's amendment. So at that point, you wouldn't have to send anything in. So as best you can, please read as comprehensively the office action as you can. I know, trust me, I'm with you. It can feel incredibly overwhelming. Especially when there's a lot of evidence that is attached, and it is in some ways, it's not jargon, but it's very precise legal language that oftentimes needs to be in there. So the most you can try and educate yourself so you can learn what it is that the office is trying to communicate to you, the better. And I would say that if you're able to, if you've gone through it and you've figured out, I've got 95, I understand 95% of what this crazy examining attorney is trying to ask of me. Well, if there's some things you still don't understand, sure, you can call them, the examining attorney, you can email them. Look, there are 700 of us, so I don't know every single person at the office anymore. But everybody that I know is incredibly nice and incredibly giving, and they want you to do well. But they're also incredibly busy. There's a huge backlog and that they're trying to work through and things. So they don't have a whole lot of time to just sit and chat and to step you through the letter and say, this is what this means, this is what this means, this is what this means. But if there are things that you're having trouble with and you're like, I got it, except for this one thing, can you help me understand what it is that you're asking here? Then the examining attorney will probably be able to help you out. So that's what I would recommend for working. The best way to work with the USPTO is to try and figure out everything you can on your own and just clarify things with the examining attorney if you need to.
All right, thank you. So we've had two that asked the same question. Can a company's tagline be trademarked?
Yeah, absolutely. Yeah. So think about just do it. Or always Coca-Cola. So, people refer to it as a slogan or a tagline, something like that. Sure. Yeah, absolutely. There are some interesting issues that come into play when you start talking about that, that we can get into if you want to. But the bare bones answer to your question, yes, a tagline can absolutely be registered as a trademark, so long as it indicates the source of your particular goods and services.
Great. All right. So there is a question. What's the current turnaround time for getting an examiner assigned to applications? And once an examiner is assigned, how long does the trademark review process take?
Great question. Typically, the amount of time that it takes between when you file your application and it drops into an examining attorney's docket, for the longest time, it was somewhere in the 2.5 to 3.5 month range, 2.5 to 3.5 months, okay? But what happened is after an initial dip after the pandemic hit, trademark filings went through the roof starting in probably the spring, summer, fall of 2020, and they have continued since then. There's just been this massive amount of filings of trademark applications. So typically we used to handle 600 to 650,000 application classes every year. We're on track, I think, to hit, it was like 100,000 in 2020. We could be close to 1 million through 2021. So you're talking a 50% increase in the amount of work that has hit our dockets. So even with 700 examining attorneys or somewhere near there, it still takes time to work through that backlog. So the current backlog is somewhere in the probably 5.5 month range. So between the time that you file your application and an examining attorney first takes a look at it, it's probably between 5 and 6 months. So it's slowly coming down because we have new examining attorneys who are coming online, have just been hired and trained and things of that sort. But it's going to come down, but it's going to take a little bit of time to get there. So that's the first part of your question. The second one is, how long does actually the review process take? Well, I can tell you, after the initial application examination phase anyway, once the examining attorney gets it in their hot little hands, they have 7 days, okay, to send you a letter, an office action, to contact you for an examiner's amendment or to approve it for publication. So they have seven-day window. But the actual examination process itself, on average, might take 12 to 18 months. So it is not a super fast turnaround time. It's quicker than patents, perhaps, because patents can take years that traditionally work through the system. So the fastest that I've ever seen a trademark go from application stage to registration phase is probably 7 or 8 months. And that's because everything was perfect in the application and it just flew through the process. And everything was filed at the very beginning, front loaded. So I would say that's the quickest, but on average, it's probably going to take a year to 18 months. But also keep in mind, a registration may never issue, all right, because you might get a refusal and that becomes a final refusal. And so you're never able to register. So that's going to affect the timing as well, because it's not a guarantee between 12 and 18 months, but it's probably on average, if you're going to be able to register, it's probably going to be somewhere in that range.
All right, thank you. So last question. A few years ago, we started an application and found it really difficult to find the exact category for our trademark. We might already have common law because it's been used since about 2017. What do you suggest to facilitate?
So I would suggest, great question. So if you started using it, then you are probably right. You probably do have some common law rights that you've created. But if you do want to apply for federal registration, I would say spend some time in the ID manual. I'm guessing that's what you mean when you're talking about finding the sort of right classification for it. Because remember, every trademark has to be tied to particular goods and services. So it would be a matter of finding the right wording in our ID manual. So you're looking for wording that is going to be acceptable to the USPTO, that it's broad yet accurate and acceptable. So I would say plug some keywords into the ID manual. It's part of the form itself, especially if you're using TEAS+. You can actually access the ID manual outside of the application. If you go to uspto.gov under trademarks, you'll be able to find a link to the ID manual. I could probably show you in a screen share if we have a few minutes. And so what I would say is you can start plugging keywords into the ID manual and sort of see what is coming up. Now, I will if you would say, Jason, the ID manual is incredibly confusing and there are lots of terms in there that I don't understand and it's not giving me the results I want, I would agree with you, right? It's not exactly like Google. And so when you type something in, pretty much what you want to look for is going to pop up. That's not always the case. And there's a lot of stuff that is in there through international agreements and things of that sort. So what you really want to do is start looking at the keywords for the goods or services that you provide and look for things that are that describe what it is that you do, right? So let's say you're a nonprofit and you're providing, business advice to underserved communities or something like that. Then you might, look for business consulting services or, things of that sort, right? So you want to, what is it that you provide to your customers? And then type keywords like that into the ID manual, and hopefully that'll help you find some wording there that is acceptable and it is accurate for what you do. The one thing I would say is, please don't just pick something because it sounds like it's kind of right, because that can get you into trouble. Because if it's not exactly what you do, then you might not be able to register that application. The one example I will give you of where an ID kind of really messed up an application was that there was a wine company and they identified their goods as labels for wine because that's where they put their trademark, right? Was on the labels. Well, the USPTO interprets that those as goods. So they're saying you are using your trademark as a brand for wine labels. Well, obviously they weren't providing wine labels, right? They were providing wine. So they were never able to register their trademark, at least not through that application, because they could never provide evidence, hey, I'm using my trademark as a brand for labels, right? So that's why it's so important that when you're doing that search of the ID manual, you don't just pick something that's close, but you try and find something that is accurate and that covers exactly what it is that you are providing. And if you get into a situation where like, yeah, I can't find it in the ID manual, Jason, well, in that case, you have a couple of options. One would be to use T's standard. Yes, it costs you $100 more per international class, but it also allows, there's a fill-in text field and you can type in the goods or services that you provide. All right, so in that case, you could put it in there. The examining attorney would then have to kind of figure out exactly what it is you're trying to do. So there might be a little back and forth, and that's where things get a little bit wonky, perhaps, because of trying to figure out exactly what's happening with what your goods and services are. The other option that you might have would be, and well, you do have, it's not might have, you do have, is to email TM ID Suggest. And those are our ID folks at the USPTO. And you can say, this is what I provide, the service that I provide. I cannot find it in the manual. Can you add it to the manual? And this doesn't happen very often. It's typically for something that is so brand new that no one has ever thought of it before. It doesn't exist as a product or as a service because no one else is doing it. So in that case, the ID folks might be able to add it to the manual. And so once it's at that particular identification is added to the manual, you could then apply using T's Plus and take advantage of that reduced $250 rate. So that would be another way to go about it, is to try and get the ID that you're looking for added to the manual. It's going to take a little bit of time for them to review it and agree that it should be added and then get it added in. So it's not an immediate sort of, turnaround time. But that would be an option too, if you say like, it just doesn't exist in the manual. What we do doesn't exist in the manual, then that would be another option.
Thank you, Jason. We actually ended up having one more question.
Sure.
This will be the final one. And Randy says, thank you for answering his question.
Sure.
All right, so the question is, I searched online and found an ASU patent law clinic. Do they submit trademark applications?
That is a great question. Let me look. You'll forgive me for looking real quick here.
Hey Jason, I think I might be able to answer that.
Okay.
Because yeah, they do have a clinic here in town. That again, it's like a lot of the other clinics. There's usually an income, requirement as well as an application requirement. And, those clinics are actually very, very valuable. But, as I tell my clients, you can't count on the pro bono services to actually execute either your intellectual property. You might be able to get some services, but it's worth a try, but it's not a guarantee.
Right. I would agree. And it also does take some time as well, because I know that, look, you're working with a law professor and a law student and stuff. So it's not super fast like you would get if you were hiring an attorney and like you become their client right away and you're paying them money and stuff like that. So you might get quicker services by hiring someone than you would by going through a clinic. And I did just look it up. In addition to patents, the ASU clinic also has a trademark sort of branch of their clinic. So you know what, here, let me, I can pop this into the, see if I can pop this in the chat here real quick. Let's see, all panelists and attendees. Okay, that's for the law school clinic. And I will also, if you want to, if you guys have any interest in coming to the boot camp, the first one each cycle, so the one on October 5th, will be really reminiscent of what I have talked about here today. So if you want a refresher on that, sign up for the one on the 5th. But if you want to go in depth on any of the other topics, such as an overview of the registration process, searching, the application requirements, and then the walkthrough of the form, and then responses to office action, and then the post-registration maintenance documents, all that stuff we do in all the weeks after that. And we do real deep dives into all of those things. So if this is something that interests you and you want to learn more about it, because you don't want to have to pay an attorney, you want to do it on your own, because you're that sort of person, hey, I support you. I'm the same way. So by all means, come and hang out with our Trademark Basics Bootcamp. We'd love to have you there. So.
All right, thank you, Jason. Lou will begin to close us out and give us some information on the SBDC.
So Jason, thanks again for the presentation and really been taking the time to answer the questions in a thoughtful manner. It's really valuable and it's really well appreciated by our clients. So again, thanks very much.
You're welcome. Thanks for having me.
Yeah, and let me just let me close up the session a little bit. We'll run up against time. So I just want to tell you a little bit more about the SBDC. You can request counseling using this link. Counseling is by appointment only. Typically, the way it runs is there's an initial counseling session where we get to know each other. I'll ask if you have me, you'll get assigned a counselor. If you happen to get me, I'll ask you a lot of questions about your business and we'll get to know each other. We'll identify some goals where we can help. And then we have follow-on sessions and, we meet on a regular basis together. We're advisors, we're not consultants, so we don't do a lot of project work. I usually meet with my clients every month or so, maybe 2, depending on what's going on. And we're always tracking business goals, because when we track the business goals, we want to move you in a direction that toward growth and increasing our metrics, whether it's sales or capital or employees. And then we report those metrics, and that's kind of how the SBA knows we're doing what we're doing. So feel free to sign up. We're always looking for good clients. Let's talk about some upcoming webinars in the next couple of weeks. Actually, for this month, there's next Tuesday, Smart Credit Strategies for Small Business Owners. We've got an SBIR overview scheduled for next week also, which I will be doing. I think we might reschedule that one, more to come. Growth with Google the week after, making your website work for you. This is a really good series of really digital marketing opportunities for our clients, and I would really encourage you to take a look at this one and look at our calendar also. You'll see here on the right here where you can register, and there's our calendar. And then there's a new one that we're doing, the Building Small Business Value Strategies for a Successful Sale, Succession of Your Business. So if you're thinking about selling your business at some time, there's a little prep work to do, and you gotta kind of get things right. So one of our specialist counselors is gonna give that one. So again, here's our webpage. We've got our COVID resources, which was really disaster assistance training. You can see our counsel biographies. You can request a counselor. Anything that's technology oriented, I typically get. You can follow us on Facebook and on LinkedIn. And so again, thank you for joining us today. There'll be an evaluation at the end of the program. Is that something you'll send by email, or do we stay online for that?
That will be directly after the Zoom webinar closes. So yeah, thank you again, Jason, and thank you everyone for joining us. I will be sending you all an email either today or tomorrow, so it'll be within 24 hours. I'll be sending you the link of the recording for today, as well as the PDF of this slide from Jason. So thank you all again for joining us, and we'll be seeing you at other webinars.
Yep. Thanks again, Jason.
You're welcome. Thanks so much. Take care, everybody.
All right, guys, take care.
Bye.
Take care. Bye.
Bye.